Members, we've got a quorum already, so may I now call the meeting to order. Please invite the administration in.
出席今次會議嘅政府官員。
We have with us the following officials: Mr. David Wong, Deputy Secretary for Commerce and Economic Development; Ms. Patricia So, PAS for Commerce and Economic Development. Then from the IPD, we have Ms. Michelle Chong, Assistant Director; Ms. Jasmine Khan, Senior Solicitor. From the Department of Justice, we have Mr. Michael Lam, Senior Assistant Law Draftsman, and Mr. Henry Chan, Senior Government Counsel. The administration has provided us with 3 papers, and they are CB4, 141501, and also CB4 1102, and also CB4 10001. So perhaps you can first of all take us through CB4 100-01.
係，多謝主席。咁我就簡單。
Thank you. Yes, let me take members through the paper on user-generated content, or UGC. Members expressed a lot of concerns about the matter, and many deputations also raised this issue during the public hearing on Saturday. First of all, UGC in overseas jurisdictions. And then, secondly, the Canadian experience. Thirdly, the Hong Kong situation. In fact, there is no uniform practice concerning UGC globally. Canada has, or is the only country which has included this concept in its copyright regime. And that in 2012, Canada enacted the Copyright Modernization Act. The source of the works has to be ascertained. There is no infringement of copyright, and the use of the new work does not have a substantial adverse effect on the exploitation or potential exploitation of the existing work or other subject matter, and so on and so forth. So, for example, this will permit users to incorporate existing copyrighted material in the creation of new works, such as making a home video of friends and family members dancing to a popular song and posting it online, or creating a mash-up of video clips. And then let's turn to Australia. The copyright legislation was updated, but then in 2013, Australia looked at whether there could be further changes or revisions to the copyright regime. So Australia did look at the Canadian experience and felt that the Canadian practice should not be adopted in Australia. They were of the view that UGC reflected a full spectrum of creative and non-creative reuses and should not automatically qualify for protection. And so in November 2013, the Australian Law Reform Commission stated this position very clearly in its final report. And of course, in this report, there are also other recommendations for the government's consideration. In February this year, the report was submitted to the Senate, and the Senate is still considering the recommendations. And in the U.S., there is the Millennium Act. And in July this year, they were looking at whether their copyright regime needed to be further revised. A green paper was released, and it was said that YouTube could use filter technology in allowing users to post remixes. And as a result, copyright infringement could be avoided. And concerning remixes, they are looking at whether the, new proposals are required. In fact, they've received divergent views. Some have said that there is no need to change the existing laws, and there's no need to provide new exemptions for remixes. They think it should be for the free market and the copyright owners to deal with such remixes. And the government can encourage the use of micro-licensing options. But then some are of the view that the fair use doctrine still has a lot of uncertainty, and so there is a need for a compulsory licensing system for remixes. So the task force in the U.S. has yet to come up with any policy recommendations. Now the EU. In fact, they don't have the UGC concept. They have the directives for all countries. But then there was a public consultation exercise launched in December 2013, and the exercise covered the subject of UGC. In fact, discussions on UGC have been taking place in many EU countries, but no consensus has been reached. And so in December last year, there was the public consultation exercise on, among other things, UGC. And views received are divergent. Views have come from users, institutional users, authors, performers, collective management organizations, publishers, and so on and so forth. There is no consensus, and the review is still going on. There is a new Commissioner for Digital Economy and Society in the EU, and one of his duties is to look at the copyright law to see how it can provide the right conditions for supporting cultural and creative industries and exploiting their potential for the economy. The UK. In the past decade, the UK government wanted to promote the creative economy. So there was the Hargreaves Review. And it was proposed that there should be more new copyright exceptions, including private copying, data mining, parody, archiving, and preservation, and so on and so forth. But then no proposal has been made with regard to UGC.
In October 2014, they have legislated for these exceptions. In the UK, in response to the EU consultation, they have expressed their view in February this year. They think that regarding UGC, online platforms actually contains some blanket licensing arrangements with users and copyright owners. They think currently there is not enough grounds to cater for statutory exemption for UGC. The last country is Ireland. In October 2013, there was a report about modernizing their copyright law. They think that the Canadian model has to be taken into account in giving new copyright exceptions. The document was submitted to the Irish government, which says that they will look into it. And in 2014, there was a plan to make a legislative proposal to the government. So far, there is no such proposal submitted. And that is the overseas experience. Let's come back to the Canadian experience. Well, the concept of UGC being incorporated into the law was abundantly discussed and supported by some people. However, there are some other people who think that the three-step test under the Berne Convention may not be complied with. In particular, the first step, that is, copyright exceptions must be confined to special cases and not conflict with a normal exploitation of the work and not unreasonably prejudice the legitimate interest of the author. So when it comes to special cases, there is controversy whether when it comes to UGC, it can really be limited to certain special cases in the protection of the right of copyright owners. And there are some authorities who have expressed their views. You will find the information on page 8 and 9. There is a reservation that when it comes to dealing with UGC on the internet, perhaps there are some grounds to give exceptions to parody and satire. When it comes to remixes, it should be left to the sector for development to be achieved and for balance to be struck. When it comes to the Hong Kong situation,
11月開始去交代返香港個情況啦。
You'll find the information on page 11. In the past year, we have had a lot of discussions with internet users talking about what kind of exceptions or exemptions that should be given. The Copyright and Derivative Works Alliance proposed the adoption of the Canadian approach, that is to incorporate UGC in our law. You'll find the comparison between the Alliance proposal and the Canadian provision under paragraph 17. They say that when 4 conditions are met, there should be exemptions. Compared with the Canadian provision, the Alliance proposal is more relaxed, because under the Canadian provision, the new work must be transformative. However, the proposal of the Alliance does not specifically require that, so the work does not have to be transformative. The second point. In the Canadian experience, the work should be solely for non-commercial purpose. And the proposal by the alliance is that it can mainly be for non-profit making, and that will be in order. The third point is that acknowledgement of the source should be a condition. In this regard, they are very similar. The fourth point, under the Canadian model, the new work does not have a substantial adverse effect, financial or otherwise, of the existing work or the potential market for it. And the proposal by the alliance is that the act does not have a substantial adverse financial effect. It's limited to financial effect, so that it's different, and it's also about existing work. So whether it is the Canadian approach or the alliance proposal, the spirit is that if it is UGC, it should not be regarded as an infringement. We have seriously looked into it. Our conclusion is clearly stated in the bill. We think that, we don't think that at this moment in Hong Kong there should be exemption given under UGC for a number of reasons. First, if we look at overseas development in this regard, and if we look at copyright conventions, there is no exemption given under UGC, save and except Canada. For the other countries, they have reservation and they're still studying it. 2. UGC is a rather vague and undefined concept. Different countries have different definitions, whether it is the EU or the OECD. They don't have the same definition, so we have reservation. And when it comes to the 3 steps, that is, the first one is related to special cases. This is an important condition that has to be met, and we need to respect that. And we think that this is not the only way to deal with exemptions. Under our proposal, the scope of exemptions are quite wide. There are 6 new exemptions proposed under this bill. The first one is for education, say for example, for the operation of archives or library work. That's the first one. The second one is cash. ISPs will temporarily allow such copies. And the third one is shifting of media, say for example from music CD to MP3. The fourth one is in relation to UGC. Parody, satire, caricature, and pastiche will see exemptions under fair use. And if there is no transformative parody or satire, if it's just for personal use, we also propose a fair deal exemption. So if it's just a screen capture or just a clip, it may be exempted. And current affair commentary. Well, currently, current affairs is under an exemption, and we do think that current affairs commentary should be given exemption as well. So, if the bill can be endorsed, we think that the majority of the acts on the internet are properly dealt with. In the legislative brief, Annex D, you will find a list of acts that are commonly found on the internet and will be exempted. Even if they are not exempted, does it mean that there will be problems, that there will be hindrance to freedom of expression or creation? If it is not exempted, and if the Act does not replace the original work, we have already clarified the criminal threshold. There will not be criminal liability. So, well, with civil liability, does it mean that there will be a chilling effect? We have reservation when it comes to this saying. If it does not replace the original work, and if there is no harm caused, is there a need to take out a civil litigation to stop you? We have a safe harbor provision. We also have some principles related to civil litigation. So frivolous and malicious litigations will be stopped. So we don't think it will hinder freedom of expression. When it comes to other countries, we don't think there is no specific exemption under UGC, and we don't see any hindrance to freedom of expression. So we think that this is a balance among the interest of different users. Of course, we have communicated with legislators as well. We realize that the development of copyright regime and the internet is fast. We keep an eye on the different trends of users and the internet. We try to amend the copyright regime once every several years. We think that our current proposal will meet our target. What happens in Australia and Canada will be a guidance to us as to which is the best and the best approach, and which is the approach that is most suitable to our situation. Thank you. Mr. Wang has used 20 minutes to explain to us in detail this paper. I'm sure members have questions. Mr. Raymond Wang, 5 minutes. Well, I don't think it's enough, but there are many people. I'm sure you can give us more time, because this is an important bill. And of course, those who are sitting here are prepared. We're not just here to vote. We're all very concerned about UGC. If you look at the entire bill, you'll realize that this is the most important point. The administration has made it very clear. Those who are concerned about secondary creations and whether there will be litigations, say for example the alliance, they have given us some very constructive views. Otherwise, we would not have spent so much time talking about UGC. It's been a number of meetings. You have given us an answer, and I'm very unhappy with it. Let me break it down to different parts. Well, there are many reasons why UGC will not be considered. In paragraph 3, you said that without overseas precedents, whether Canadian UGC exception is effective in the protection of copyright. And there are controversies, especially when it comes to whether it complies with 3-step tests under the Van Convention. And it says here that the UGC exception has attracted considerable discussions and comments. It seems that the administration is very insistent on saying that there is no overseas there is no overseas precedence. So I think you just pick and choose whether, as it suits you, whether there is overseas precedence or not.
Mr. Wong, can you find any precedent with regard to one country, two systems? Socialism with Chinese characteristics. Can you find another precedent? Do you know that this is tantamount to the most extreme form of capitalism? So what is meant by international precedents? You're not discussing the matter with us at all. How come we can't have a regime of our own? Why is it that we have to make reference to international precedents? Because those who are involved in secondary creation are worried. So you've only included 3 things, and this is not enough: parody, satire, and also pastiche. So there should be and concerning the criminal and civil standards, they are more relaxed than those adopted by our administration. Do you know that young people are really concerned? They've done a lot of research. The devil is in the details. And so we really must go over the details with you in great detail. And then let me now refer to para 5. It is said that the dividing line for non-commercial purposes may be too vague. And then there are other concerns. Now, I want to say that, in fact, for those who support UGC, they want to have UGC for non-profit making purposes. Please understand what they want is different from what there is in Canada. And then I want to talk about the subject matter. I understand that you are concerned about the rights of copyright owners, including their monetary and non-monetary rights. But this is the copyright bill, and of course the copyright bill seeks to protect intellectual property rights. So do you know that according to the alliance, the greatest difference between the UGC proposed by the alliance and the UGC in the Canadian provision is concerning or rather the Act does not have a substantial adverse financial effect on the exploitation or market for the existing work to the extent that the work substitutes for the existing work. I understand that if lots of films and pop songs are shared without the copyright owner's consent, that may not be acceptable. But here we're talking about not substituting for the existing work. We're not saying that people can unlawfully download copyright works. We're talking about UGC. And I've got one more point, 1 more minute, Chairman, 1 minute only. Because I have some, I want to make my presentation complete, and then I have some questions on points raised last time. And then with regard to commenting on current events, I think the exemption proposed is not clear enough. Can you explain the under what circumstances and will there be exemption? Under what circumstances can there be protection concerning commenting on current events? And it seems that the government mainly makes reference to the advice given by WIPO. And I hope that you understand that he has also given other views. For example, he has said that under certain circumstances, it would be good to restrict the scope of exemptions. For example, reference should be made to the Berne Convention 10b(ix). So I hope that these suggestions can be taken into account, or I will definitely move my own amendments. Yes, Mr. Wong. Yes, I thank Mr. Wong for his comments. I have listened to what he has said very carefully. In fact, our primary purpose is to protect the rights of copyright owners. And my colleague, Ms. Chong, will tell you more about exemptions with regard to commenting on current affairs. And we think in Hong Kong we can adopt better practices. And with regard to the international conventions like the Berne Convention and the WIPO's international conventions or the TRIP, Hong Kong has to discharge its obligations under these conventions. The conventions or agreements clearly state the international obligations. Now, my question is whether UGC is in compliance with these international agreements or treaties. Yes, I understand that we are in SAR under a signing party, but I want to see whether I want to know whether UGC has breached these agreements or treaties. Yes, Chairman. In fact, there are reservations, and I would now like to point out that some users have said that it would be all right if the works is for non-profit making and so on and so forth. But then what is meant by for a personal purpose and not for profit making? Is that enough to protect the rights of the author? What if financial losses are caused to the author? Now, the new work may be done for non-profit making purposes, and still there may be losses incurred on the part of the author. And so we can't say that it's enough to say that it's for non-profit making purpose and it's for a personal objective. So can you give me some concrete examples that it would amount to an infringement even if it's for non-profit making purpose? You can't simply say non-profit making UGC also amounts to an infringement. So what if this has hurt the feelings of the author? I think you have to be specific. You have to tell us why this is an infringement. Yes, thank you. Now, there are lots of intermediary platforms on the internet, and people can upload materials onto those platforms for sharing. For example, YouTube. But last time I said that YouTube rigorously monitored possible infringement when we do have programs on the internet and on Google. When we want to share the advertising revenue, there must not be any infringement at all, and so they themselves have rigorous systems to guard against infringements. Yes, but then if we in a piece of legislation says that UGC will not amount to infringement, then the system will do the screening in accordance with the law. So if we allow matters or content to be uploaded for non-profit making purpose and for personal objectives, then does it mean that there will not be any loss to the author at all? The answer is no. So we in this piece of legislation are seeking to protect the rights of copyright owners. I think you have responded very quickly, but then I don't think your arguments are really convincing. Now, please do not start talking directly to one another. So the paper has been provided, the reply has been provided, and it's up to you to decide whether you think the reply is satisfactory. Concerning commenting on current affairs, Ms. Chong, please. Yes, thank you. Now we have a copyright. We are proposing a copyright exemption for commenting on current affairs because during the public consultation exercise, the Bar Association said that the existing copyright law provided an exemption for reporting on current affairs, and we have looked at the unique local situation. Many internet users are concerned about current affairs. They are not reporting on current affairs, but rather they are commenting on current affairs. And the Bar Association is of the view that the exemption should be expanded to take care of the unique local situation. So concerning reporting on current affairs, commenting on current affairs, we have to look at whether the exemptions proposed are in line with or in breach of international treaties and conventions. In fact, for reporting on current affairs, the scope of the exemption is very wide. But, of course, the premise is that current affairs and news are reported for public information, and this is not restricted to the activities of journalists or reporters. There are members of the public who do disseminate information to the public, and this is also a role of reporting on current affairs. You may say that, in fact, current affairs have been reported on. I just want to make some comments. I just want to give my views to stimulate further discussion. And does that amount to reporting on current affairs? So having considered the Bar Association's comments and other factors, we are of the view that to allay public concerns, in order to be clear, in order to respond to society's demands, we think it is appropriate to expand reporting current affairs to include also commenting on current affairs. That will not be a breach of international obligations. In fact, the UK case tells us that in fact there is room to expand the scope, and at the same time we can fulfill our international obligations and also meet the demands of the public. And then Mr. Wong asked what was meant by commenting on current affairs. I think we have to rely on the common law. In fact, there is no really specific definition on what is meant by reporting on current events. So we rely on common law precedents and also a common understanding.
When it comes to commenting on current affairs, there will be comments and there will be criticisms. We'll look at it objectively to see whether it's commenting. If it's mere reporting, then it will be exempted under reporting of current affairs. But if there are comments, if his personal views are expressed, then it is commenting, and an exemption will be given. I hope the information will be of help to members' understanding of our rationale. Next, Mr. Ray Chan. Well, the administration has been talking about fair dealing. They say that this will address the issues. And sometimes when they copy overseas laws, they only do it halfway. Well, under the latest UK legislative amendment, when it comes to parody and satire,
contract purpose to prevent or restrict the doing of any act which, by virtue of this paragraph, would not infringe any rights conferred by this chapter. That term is unenforceable. 意思就係話呢，版權持有人係唔可以。
In other words, that the copyright owner cannot, by way of a right, restrict the exemptions under parody, satire, caricature, and pastiche. But I find that in this legislative amendment of Hong Kong, that part is not adopted by us. So they've only done a half-baked job. Say, for example, is the terms of use of a product. If it is not abided by, does it mean that there can be civil litigation taken out by the manufacturer against the customer? Will you consider incorporating a similar provision like the UK legislation to allay concerns? Perhaps I will try to answer your question as to the UK. There is a contracting out or contract override. It is done by way of terms of a contract to impose restriction. As you say that they are in relation to parody, satire, or private copying. There are just a few exemptions. They cannot be contracting out. So users can still enjoy the exemptions. The reason why there is such an exemption in the UK, you see that there has been a few rounds of consultation. There is a Gowers review. In Gowers review, there were 3 consultations, and then there was a Hargreaves review. They consider whether there should be some provisions in statutory exemption to in relation to limiting the exemptions. In the Hargreaves review, they say that all exemptions should contain these provisions, but that is a very controversial matter. Don't forget that this issue has been under discussion for 5 or 6 years. And in the end, when it comes to parody, there will be some provisions. If there are terms of a contract restricting the use or prohibiting the use, and if it is if it is in conflict with the statutory exemptions, then these terms of contract should not prevail. And in Australia, they also talk about contracting out. There has been an in-depth discussions back in 2013. The conclusion was that it's impossible to introduce across-the-board restrictions because this involves freedom in the contracts. And Mr. Chen asked why we did not introduce it. This is a significant issue. If I remember correctly, back in 1994 in Hong Kong, the Law Reform Commission considered whether there should be explicit stipulations forbidding terms of a contract not to be to be exercised, not just in relation to copyright, but as a whole. There has not been any consultation, so we should not rush by introducing these conditions or provisions. So does it mean that even when this bill is endorsed, that can be terms of contracts to override exemptions related to parody, satire, caricature, and pastiche? Well, there is a basic legal principle if it is done by contract. There is a contract responsibility on the parties to the contract. But when it comes to the use of copyrighted materials on the internet, we know that a majority of the users are third parties, not a party to a contract. But if I buy a disc, then I am a party to a contract. Yes, that is the case, but the exemption we propose are there to help the majority of users who are not parties to a contract. Well, I think Ms. Chong can talk about the legal side of it. I don't understand what is the difficulty in incorporating it. Well, the copyright regime is one area, and under the contract law, that is a different area. And if certain conditions are met, then you will enjoy an exemption. So under the copyright ordinance, you enjoy an exemption. So the copyright owner cannot sue you for infringement. That is the exemption under the copyright regime. You mentioned that in the UK, there are terms of a contract. Say, for example, you've bought a disc or a book, then you are not allowed to copy it. And in the UK, it says that if there is such terms of contract, however, under the copyright regime, you can legally photocopy certain parts of it. Then you cannot use the terms of the contract to invalidate the exemptions under the copyright regime. So if you are given exemptions under the copyright regime, you will then a party cannot sue you for copyright infringement. But whether that party can take out other litigations, that's a different matter. And in the Hong Kong context, we see that a majority of the users are not party to a contract with the copyright owner unless you borrow a book in a library. So when it comes to provisions that impose restrictions through terms of a contract, that is our concern. So if you buy a disc, if you buy a book, and you use it for on parody, then you may be claimed because you are party to a contract. But if you just find it on the internet, there is no contractual relationship. Is that right? Maybe let's take a step back. If an exemption is given to you under the copyright regime, say for example for parody current events, then a copyright owner will have to look at the needs of the users and the copyright provisions. If it's unreasonably used, then they are hurting themselves because they discourage users. For different products, there may be different users. If A uses unreasonable conditions to impose restrictions, then his products may not be as popular. Customers will switch to other products from other suppliers. So it's for the market to decide. That is that people will not buy from parties that strictly use the law. Well, I'm just saying that your worry may not be realistic. So they have to write a term to override the exemption, and then in the future they can take out a civil claim. Yes, in principle. But you have to look at it in the context of a real commercial world. When we have given exemptions and they still want to write these terms in the contract, how prevalent do you think it will be? You have to consider whether it is just being overcautious or maybe worrying too much. Well, but then I asked the administration to take into account of adopting the UK provisions. Mr. Liu, some technical questions. There is the ownership, and there are some derivative rights, moral rights. So when it comes to parody or caricature, it's very likely that it will infringe on moral rights. So is it the case that infringement of moral rights is included? If not, how is it handled? Ms. Zhang, when it comes to moral rights, there are three types. One is the right that it is attributed to you, the right of attribution. That is that if you cannot change it to the extent that it will affect me. The second one is false attribution. That is you are not the author and you changed it and then attribute it to me. So these are moral rights. Members asked whether these exemptions cover moral rights. For some areas, say reporting or commenting on current events or parody, in the reasonable circumstance, when the source is acknowledged, then there can be exemptions. But if it is not reasonable to acknowledge, then there can be exemptions. So there is a relaxation when it comes to the right of attribution. And when it comes to changing or altering the material, which in fact affects the reputation of that person or the false attribution. In the latter two, we have not changed anything. So whether it is secondary creation or the use of copyrighted material, there should not be any adverse impact on the moral rights of the author.
民事嚇。
So civil means can be used, only civil, not criminal means, I must hasten to add. So if if the author's reputation is tarnished, then civil action can be taken. So concerning the moral rights of the copyright owner, that will be preserved, and that's like the case in the UK concerning derogatory treatment. Last time, I referred to a case where a World Cup soccer player bit another player. And then what if there is parody, caricature in relation to this scene? But what if there is no secondary creation? What if a person just upload this clip? I want to say that concerning UGC, it is said that the UGC cannot satisfy the three-step test. I want to refer to paper CB4100-01. It is on why countries have decided not to include UGC in their copyright regimes, and why Canada has decided to do so. Now, in fact, the Copyright Alliance has in fact also given some views, and I want to say that the Alliance and the administration are of the view that UGC represents a wide and vague concept, and there is no widely accepted definition in the international community. And so the first step under the three-step approach in TRIPS may not be met. Now, I want to raise some queries. The administration says that UGC is a very wide and vague concept. But then concerning parody, irony, caricature, satire, again, these are very wide and vague concepts. So concerning parody, satire, caricature, and pastiche, you can refer to the Oxford Dictionary. What is meant by caricature is about exaggerating certain characteristics in order to give a humorous effect. But then, what is meant, how can you say that there are objective criteria? I remember Mr. Leung Chi-Cheung said that umbrellas, in fact, could be weapons. He said that Master Huang Fei Hong used umbrellas as weapons. And Mr. Leung Chi-Cheung will never admit that what he said amounted to a caricature. But then I think what he said amounts to caricature. So how can you just say that UGC is a very wide and vague concept? And may I refer to paragraph 37 of the Lechko brief. It refers to a EU document. So how come you're saying that definition is vague and also too wide? How come you're saying that there is no widely accepted definition? There is because I think, and I'm referring in fact to the Secretariat brief, and I think that is more credible than the electrical brief or than the administration's proposal. So I just want to say that in fact they do have a definition. Now please be concise because I still have lots of questions for you. Concerning the soccer player biting another player, some asked whether there could be an exemption. And that's why we've introduced a new exemption in the bill to take care of this situation and all similar situations. And then as to whether UGC is a vague term or not, parody, caricature or pastiche or satire, these are areas of exemption in other countries, and in fact there are also previous court cases. So we know quite specifically what these really mean. In fact, when we talked to the internet users, they also asked whether there were definitions for parody, satire, caricatures, and so on and so forth. But then we said that a competent judicial or a competent judiciary should be able to come up with fair judgments based on the merits of individual cases. Now because there can be factors that can assist the courts in coming to a fair judgment. And then UGC, whether there is a definition in certain documents. Now, yes, there are certain documents seeking to define UGC, but then some countries have admitted that in fact these are not really very good definitions. Now the Australian Law Reform Commission has said that UGCs cover a very wide spectrum from creative to non-creative reuses. Now, but of course, we have different views. So now, have you consulted the WIPO? Is it that UGC cannot satisfy the criteria while parody, satire, and caricature can? I think you should provide us with the relevant papers. And then fourthly, has WIPO looked at whether its members have complied with the criteria or whether they've breached the criteria? And if there are no clear definitions, then how can the WIPO rule that certain members have not complied with the criteria? Chairman, the signatories have already signed to discharge their obligations under the treaty, but then concerning actual discharge of the obligations is for individual countries to give effect to such obligations in their respective legal systems. Now, say for example, under the Hong Kong regime, if one party feels that he has suffered losses, then a proof has to be given. So there are a range of factors for us not adopting or not proposing to adopt UGC. We are now still discussing the policies. We're not studying at the clauses yet. And of course, if it seems that I am not able to convince you, so can you try to convince me that you are right? Chairman, I'll try to use 1 more minute to try to convince Mr. Wong. In fact, there is no authoritative organization which has really given a ruling as such. But then I think whether we have to look at whether we have already exempted most of the acts concerned, and the answer is yes. Now, because our civil system does not deal with cases not involving losses on the part of the authors, such complaints would be regarded as frivolous. And I want to say that the copyright regime keeps evolving. We have a rigorous copyright regime, and we embrace such a regime. And so we'll continue to monitor international practices. Thank you. So Mr. Wong is telling us that he is not ruling out the possibility of incorporating UGC in the copyright regime in the future. And I think concerning whether UGC can satisfy the 3-step test, now I think we should err on the relaxed side. I think there is no proof that UGC can't satisfy the 3-step test, and I think you should not ask us to pocket the present proposal first. I think to err on a safe, lenient side, you should give it exemption. Different countries are now in the experimental stage. Hong Kong has its own copyright regime. You know that the netizens and those involved in secondary creation have this very big concern. And so I think you should give this suggestion further thought. Mr. Chen Chi-chun, thank you. The administration is unwilling to consider adopting or including UGC because it suspects that the 3-step test may not be satisfied. But then Professor Peter Yu has said that the 3-step test can be satisfied. It says that the WIPO, he says that the WIPO says that so long as the area of exemption can be specifically delineated, that would be okay. And then 37C covers step 1 and step 3 of the 3-step test. So does it mean that the only remaining hurdle is step 2? Ms. Chong. Yes, Chairman, concerning Professor Yu's arguments, Now, I want to respond here. Professor Yu is saying that step 1 is about ascertaining specific cases, and he is saying that there are different views among academics, and there are some who feel that the Canadian UGC exception complies with the 3-step test. And there is an article by WIPO on whether UGC should be introduced to Hong Kong, and there are 7 reasons for following the more prudent approach adopted in EU instead of hastily following the Canadian example, and at least this is the case for the present bill.
And the first point is that whether it meets the first step of the 3-step of TRIPS, he thinks in this regard is not suitable. In Canada, there are some scholars and some authority on some authoritative scholars and lawyers of the copyright regime express doubts, and they have concerns. One of them is outlined in the paper. Currently, there is in Canada only that you will find UGC. And if you communicate some content on the internet, it's actually boundaryless. If the Canadian approach is not the mainstream, then Canadian users will face an unnecessary risk, because they would think that they can upload secondary creations or copyrighted material onto the internet under the UGC. Maybe on Canadian soil they are protected, but there is no such exemptions in other countries. So these users will face the risk of infringement. And that is the concern expressed by lawyers in Canada. And the member mentions about Professor Yu. Different academics have different views. Mr. Yu, Professor Yu thinks that when it comes to the first step, well, there is no special delineation of the scope, and the scope varies from person to person. There is such a risk. So is this a right time to introduce UGC? Or as Dr. Fisher said, that we have to be careful. We've never said that it will never be suitable. It's just that we want to take reference from further development in overseas jurisdictions before we decide. Last time, some people say that if we have UGC, then Hong Kong will be included in the 301 list by the US. Well, let's put this the other way around. If we do not follow the international trend, then Hong Kong will be criticized for not doing it. This is a significant issue. I think it's difficult to comment on how they see UGC. Any other questions? If not, this paper is dealt with. Next is CB 411/14 to 14 bracket 05. Bracket 01. Perhaps Deputy Secretary, you will be brief. I'll ask Ms. Chong to take you through the paper. Yes. In the second meeting, Mr. Kwok asked us for some information about the concept of substitution for work and whether there are any overseas examples. Well, the concept of substitution for the work. Well, one of the offense in the bill is prejudicial distribution. Well, if it is personal prejudicial distribution, but it harms the interest of the copyright owner. Well, there are some similar provisions in the UK and in Australia when it comes to penalty against prejudicial distribution. And, well, we have taken reference from some authorities when it comes to the extent. Is the Chen Naiming, that is Big Crook Authority. And at that time, the court said that when it comes to the prejudice, it should not be limited to finance, and we should look more than the existing prejudice, but potential ones as well. In the magistrate, there is a judgment on a prejudice. But there is no further discussion on the word prejudice in the higher levels of court. So when it comes to financial prejudice, we're talking about whether the work will be affected in the market, and as to whether there are similar cases. In UK, there is in R versus Emmanuel, namely, a university student recorded a newly released films in a cinema with his mobile phone, and he was charged with prejudicial distribution. He pleaded guilty to the offense, so the court did not have to have a discussion on the word prejudice. This is regrettable because we won't. As a result, we will not find any discussions by the court on what constitutes prejudice. In Australia, someone uploaded some pirated software onto the internet for other people to download. Something has been done for that pirated software to be easily found on the internet. The defendant at that time was in Australia, and the copyright owner took out a litigation. Well, the U.S. court is of the view that it has to be an offense in Australia for action to be taken. And as a result, there was a 1968 Australian Copyright Act, which makes it an offense. The Australian court was of the view that the defendant uploaded some pirated software onto the internet. This creates an illegal substitution for the original work. And as a result, it substitutes the market. It substitutes the original work in the market and as a result causes prejudice. And there is a criminal element, and as a result the defendant was extradited. So when we consider prejudicial distribution, we will consider whether it is a substitution for the work and whether it provides an alternate and illegitimate source. These are important because this will cause financial loss to the copyright owner. We have taken those cases into account together with the Hong Kong Chennai Ming case. Copyright owners and users both think that if a piece of work substitutes the original work, then it is a determining factor. So we propose substitution for the work becomes a factor in determining the extent of prejudice. Next is bracket number 2 is in relation to cases of fair dealing. It will be me again. Just now we were talking about criminal matters. Now we move on to civil matters. A member asked whether there are some case laws reflecting fair dealing provisions. Well, there are a number of fair dealing provisions. Say, for example, research and private studies, criticism, review and news reporting, education and public administration. And under these existing fair dealing provisions, we find that the existing sections 38 bracket 341A2 and 54A2 stipulates that when deciding whether dealing with a work is fair dealing, then the court should take into account the purpose and nature of the dealing, including whether the dealing is for non-profit making purpose and whether it is of a commercial nature. 2, the nature of the work, and 3, the amount and substantiality of the portion dealt with in relation to the work as a whole. And 4, the effect of the dealing on the potential market for a value or value of the work. Well, for consistency and clarity, the new exemptions will also see some fair dealing provisions for the court to decide. There are some overseas case laws, say in the US, under the Copyright Act 1976, Section 107, it's said that the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by other means for purposes such as criticism, comments, news reporting, teaching, is not an infringement. And they've also expressly provided the number of factors to be considered, which is very similar to the situation in Hong Kong, that is the purpose and character of use, whether it's a commercial nature or non-profit in nature. 2, the nature of the copyrighted work, that is the original piece of work, and 3, the amount and substantiality of the portion used. And lastly, the effect of the use upon the potential market for or value of the copyrighted work. Now, they call it fair use, we call it fair dealing, but the provisions are largely similar. And when it comes to the interpretation of the U.S. courts, when it comes to parody, satire, and appropriation art, the court says that transformation is an important factor to be considered. That is, whether there is something new added to it, thereby changing the nature of the work, by injecting new ideas into the original work, giving it a transformation.
This is directly related to whether the purpose is of a commercial nature or not. And then the second factor, the nature of the copyrighted work. We look at whether the work only provides some facts or data, or whether there is a lot of creativity involved. Now, for works with data, facts, of course, there will be less copyright protection. That will have a bearing on the ruling. Then the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So we look at whether it's used to a suitable extent, or whether, both quality and quantity are looked at. So that's of course one consideration. And then finally, the effect of the use upon the potential market for or value of the copyright work. And the higher the level of transformation, or the only a small amount of the portion of the copyrighted work is used, then it's less likely that it is going to be a substitute in the market. In the UK, there are these case laws. In the UK, they haven't, like in the US and in Hong Kong, listed the fair dealing factors. But then they adopt an objective standard to look at all the facts and all the relevant factors. And the relevant factors that they take into account are similar to those in our regime. First of all, whether there will be commercial competition, whether there will be substitutes for the original in the market. So this is of course a very important consideration. And then only a suitable amount, only a suitable amount of the copyrighted work is used. Then how the this person has got hold of the copyrighted works? Have they been published? Or whether the copy was obtained by the defendant by theft or other misappropriation. But then there are exceptions, for example, public interest, and a fair dealing can also apply in such a case. So the UK, the most important factors include whether the work has been published and the motives of the alleged infringer. For example, whether the user was merely dressed up in the guise of the permitted purpose. So you can see that in the UK, although the factors to consider for fair dealing are not clearly stipulated in the law, yet the factors are similar to the factors for fair dealing or fair use in Hong Kong or the US, respectively. Mr. Ma Fung Kwok. Yes, Chairman, thank you. In the UK, they do not have fair dealing provisions. So, so some have asked why, how they can resolve the problem. And then the existing exemptions cover comments or commenting or reporting on current events. And so we just want to know whether the new exceptions or exemptions proposed will duplicate some existing ones. And then second, the scope of the exemptions has been expanded. Still, there isn't really an exhaustive list as such. And the factors will be for the reference of the judges in coming up with fair and reasonable rulings. In the U.S., they have fair use experience, and so we've mainly made reference to the U.S. practice. But then in Hong Kong or in other common law jurisdictions, do the courts or have the courts ruled on such cases? For example, artistic creation and also reporting on current events. Do our courts have the experience of ruling on such cases? Because I understand that there are some concerns in society, and how can such concerns be allayed? Yes, Chairman. Of course, we have full confidence in the quality of our judicial system. Our common law judges listen to the plaintiff and the defendant and come up with fair rulings and judgments. And our judicial system provides for explanations given by experts or evidence given by experts as to say whether certain acts amount to parody or caricature, and then whether the proposed exemptions will duplicate existing ones, whether it is necessary to propose these new exemptions. I want to say that we want to encourage creation. So in other words, we offer protection in the law for the intellectual property rights. But then such rights are not absolute, and there are exceptions under certain circumstances. We do have legitimate reasons for providing and proposing exceptions. And there are good reasons for the exceptions. Yes, it's true that the scope may be wider, there may be some duplications, but then so long as there are good justifications for proposing these exemptions, then such exemptions should be proposed. For example, we now have the existing exemption of reporting on current affairs, and in the future, there will be an exemption for commenting on current events. This will promote further safeguard the right of the freedom of speech. And we at the moment have an exemption for commentators, but then considering this additional exception for satire, I don't think that really is a duplication. I think that the new exemptions or exceptions offer greater protection. And then now we are providing some factors for the courts to consider in relation to fair dealing. I think it's a common practice to remind the courts of the factors that need to be considered, but then we will not tie the hands of the courts, so to speak, because we should give the judges leeway to interpret the law. There are some factors which are laid down in the law, or rather to remind the judges that they need to take these into account because they are regarded as very important factors in other jurisdictions. But then the courts need the flexibility to study the arguments put forward by the two sides, and I think this is in fact a time-honored practice. Mr. Ma. In fact, during the public hearing, both sides expressed the worry or the concern that our courts might not have the experience in dealing with such cases. So I just want to know what you can do to allay the concerns of both sides. Yes, Chairman, thank you. I think Mr. Ma is concerned that in ruling on whether there is fair dealing, whether courts will tend to, or whether courts may act in a slightly lopsided manner. Due to time constraint, I was not able to explain each and every case to show how courts analyzed each and every case and came to a fair ruling. Now I want to say that in this paper 02, in fact there is an appendix, and there are very clear explanations, so members can read the appendix. In the UK, they didn't include the factors in the law, but then they rely on their case laws. And these case laws are of great reference value to us because we are a common law jurisdiction. So concerning fair dealing, whether a substantial amount of the copyrighted work has been used, these factors are taken into account by the courts. We don't propose to give an exhaustive list of factors so as to give the courts flexibility amidst certainty in accepting factors that we have not thought of. So courts can make reference to the list of factors and also case laws in other jurisdictions. In Hong Kong, we only have one president at the district court level. And if I remember correctly, The case was related to reporting on current events. And the court ruled that a more relaxed approach could be adopted to assess whether there was fair dealing. So we are confident that the courts will not be lopsided. The courts will give rulings in accordance with the legislative provisions as well as case laws.
When it comes to fair dealing, of course, I think that, Michelle lists out all these factors to help the court in deciding. How come that in the future, when it comes to reporting on the current event, there is not a list? Because currently there is no factors, and they are specified in the bill. So it comes to my mind that when there is a list, then it will reduce the flexibility exercised by the court. In the UK, you say that they are not set out in a list because it evolves with a case law. Well, but here, of course, there is a conspiracy theory that with the list, they will not be fair. And in the future, will you amend the factors? Let me explain why the list of factors is not there when it comes to reporting, and now it's newly added. Current provisions, some of them, are enacted in 1997. I talked about 3 existing provisions related to fair dealing provision. 38(3), that is for research and private studies. 41A is for education. And 54A is public administration. And this has set out the 4 factors with which is a non-exhaustive list. And if you say, well, these factors are not freshly introduced in this bill, they are already there. The only difference is that in the original provisions, when it comes to fair dealing, those that were enacted in 1997 and those that are added in 2007, there is an inconsistency. So we take the opportunity to add all these factors to all the fair dealing provisions to achieve consistency. And that is the only reason why the factors appear in some provisions and not others. We spotted the inconsistency, and we want to align the practice. If there are no other questions, well, let's leave it at that. We've dealt with 3 papers. It's now 6:20. Let me remind you that the next meeting will be on the 18th of November, 10:45 a.m. If there are no questions, meeting adjourned. Well, I know that after the last public hearing, a lot of views have been expressed, and the administration is preparing a response. I think it will come to us in a week or 2. The Secretariat is collecting the written submissions, and they will also be forwarded to the administration. If in the last meeting we do not have the documents, we will not start the clause by clause. If there are no problems, meeting adjourned.